resolution, approve the settlement.
We are now in open session. We have before you Resolution 12-2019, resolution approving/disapproving litigation settlement. You have two documents in front of you. You have the resolution to determine, and you have a strategy document and outline, both of which I believe can be amended. But we must bring the resolution to the floor.
Mr. Chairman, what's the voting mechanism?
As with all resolutions, it's going to be the screen.
What?
The screen.
Yeah.
50% or 66 and 2/3?
It's a majority vote.
Supervisor Wenzel, I'm sorry. Okay, so we have a resolution in front of us. Supervisor Wenzel makes the motion. Supervisor Gibson seconds. Any discussion on the motion?
Yes. What was the motion?
The motion is to bring Resolution 12-2019, which is a resolution to either approve or disapprove this litigation settlement that you have before you. There will be a discussion. There will be amendments.
Page 44 is that. Yeah, resolution.
Okay?
Supervisor, did he brought the motion to approve or to approve? So that's the motion before you is a motion to approve the.
I'm sorry. I apologize, Supervisor Rigo. Okay, so for clarification point, Supervisor Wenzel has offered a motion to approve the resolution of the litigation settlement that you have before you. That is a motion to approve. It has been seconded, I believe, by Supervisor Gibson.
They get to go first.
Yes.
Yes, thank you.
Thank you. You have a motion and a second. Does the maker of the motion wish to speak to the motion? Supervisor Wenzel.
We have gone through the reasons why we could disapprove of this settlement, but just because we could disapprove of the settlement and fight it against the interests of open government does not mean that we should do that. I think that this body is a duly elected body of open government. We should be that open government and not get into this arrangement again.
Thank you. Does the second wish to speak? Thank you. Let me have your button. Thank you. Supervisor Gibson.
Thank you. I agree with Supervisor Wenzel. This comes down to should we instead of can we, and I don't believe that we should be withholding information from the public. I believe we should be governing in the most open methods possible, and for that reason and the reason of transparency, I believe we should accept the settlement as a whole, as it is, and move on from here.
Thank you. Supervisor McCumber.
Thank you, Mr. Chairman. I'm just going to kind of, for the record, I stand by my position that had we gone into closed session at the January meeting, we could have had this conversation, and the litigation settlement, excuse me, in front of us today would have been more palatable because we would have strongly understood that perhaps most of the board, or there was an agreement amongst the board that we were moving towards a reasonable approach to settle with the Baraboo News Republic. The records laws are there not so the county can hide. They're there to protect people. And when you look through this document, they all involve people, and it's something we should always keep in mind. But that being said, I would also like to say, and I know that I think Tim is here, right? Happy birthday to Tim Damus, because he's celebrating his 29th birthday again. But Tim, if you would please report to your superiors. I'm very disappointed this was the headline before we could have an opportunity to even know this dollar amount or even discuss it as a board. Thank you.
Supervisor Kriegel.
Thank you, Mr. Chair. I wish to amend the motion to change the fiscal impact here. And on page 3, on point 2, I would change the sentence after the title of that, of 2, to say, the county will pay the Baraboo News Republic $10,000 and the county's insurance company will pay the Baraboo News $35,000 within 30 days after this agreement, after the execution of this agreement.
Point of order, we don't have that ability, I believe. We can't make a commitment on behalf of the mutual insurance company.
I think that's correct, Chair. Now, we could be directed by the board to approach the insurance company to ask for a greater sum of money. But then you would need to condition what you would want to happen if the insurance company said no. Otherwise, we'd be back here addressing this resolution again, which is why, to some extent, this is worded the way it's worded, that the resolution, the settlement is approved subject to direction to the administrative coordinator, the chair, and the corporation council. So that would be one way to do that without actually specifically amending the settlement document to specify a particular amount from the insurance company, but rather to simply direct staff to seek additional monies, but if those monies are not forthcoming from the insurance company, then provide direction on what the ultimate settlement would be.
We're here to discuss strategy.
We are beyond the strategy. Yeah, the strategy discussion is over because we are no longer in closed session under that limitation.
We could amend this, and I think what Tom is doing is amending it, and we would have to come back and have the discussion again, which I'm not opposed to.
Yep, but I was responding to Supervisor Krieger's point that that's correct. I mean, we can't, we don't have any authority to, compel the insurance company to pay a certain sum of money. We can certainly ask, but
We can tell them what we agreed to.
we can tell them what we agreed to. Right? Yeah.
To ask the board if that's our prerogative, majority is. We can do that right now with his amendment.
Yes, I think rewarding it. Yes, yeah.
And if they say no, do we come back here?
You would have to come back. Yes.
I think, didn't you also say that given what the direction of the board would be in this, that Corporation Council and Administrative Coordinator and Chair should approach the insurance company and negotiate with them whatever we can negotiate above and beyond the $10,000. That is, this board empowers us to do that. If the insurance company denies that increase, then you may also empower us to revert to the original agreement. So we do not need to come back and meet again. Is that
Point of order, could we have a second before we get into discussion? I'm not sure of the motion.
That was an amendment, right?
Yeah.
Say it again.
But I think the wording of his amendment was what we were now trying. I think Supervisor Marty indicated that it is most probably out of order for us to demand funds from the insurance company, and we're trying to find the right wording that would empower us to continue this process forward in the name of the board, and also have a Plan B, which would be this original document if we could not move the insurance company to provide more funds.
Yes.
So be it.
The second should be able to address the original amendment first.
I'm not sure there was a second.
I did second.
You did. Okay. Thank you. I'm sorry, Craig. I don't feel well. Can I come with you?
Yes.
Daniel, I'm sorry. Where are we?
You have a second.
You have a motion and a second.
Yep.
Okay, so we're bringing it to discussion, right? And we are now discussing, oh, you didn't get to speak. Thank you. I'm sorry, it went just right over my head. Supervisor Von Aston, what number are you? Sorry. Speak.
Thank you. I think it would be helpful if we repeated Supervisor Kriegel's amendment to the board so they could hear his new wording.
On page 3 of the blue copies, there's a point 2. And in the first sentence, after the title of that paragraph, my amendment would change it to say, county will pay to the Baraboo News Republic $10,000, and the insurance company will pay $35,000 within 30 days, and the rest of it remains the same. That's what I stated as my amendment.
Thank you. Now, to me, that seems like a far better deal for Sauk County citizens who never had any type of representative committee or board agree to get in this mess in the first place. And secondly, so tired. Can't keep a thought in my head. I had really something good to say there, folks, but it's gone. Let me see if I can grab it back real quick. I'm trying, man.
Does it mean time?
That really sucks. Just went right away.
I'm sure we'll come back to you.
Yeah, I know. At the bottom.
Thank you.
Point of order. So with this amendment, if we approve it, and if the insurance company says we're not paying $35,000, agreement's done. Boom, blows up, right?
Yes.
And in 30 days.
That's bizarre.
I think that the insurance company decided that we should be in this lawsuit, as far as I understand it. They should be taking the cost through it. And frankly, we shouldn't be paying anything. They should be giving us an apology. That's my position.
Supervisor Kriegel, are you open to a rewording of your amendment to include it as a recommendation to negotiate with the insurance company, and if that negotiation is not successful, then to return to this fundamental agreement.
Or how about returning back to the board?
We're going to have the same discussion that we've had. So I would recommend if we can simply use your language to say in that paragraph that the board empowers the Corporation Counsel, Administrative Coordinator, and Chair to negotiate with the insurance company to pay $35,000 rather than $10,000, and that the county will pay $10,000. If that is not successful, then this agreement will go forward as written. The agreement, the ultimate issue here is about money, right? That's what I hear. Are we going to pay as a county $35,000 or $10,000? You just approved $300,000 for something in highway. We're a $91 million operation, ladies and gentlemen. We are a $91 million operation. Somebody calculate what $35,000 is of $91 million, and there's going to be a lot of O's before that decimal point.
You sound a little like Edward Dirksen, though. $1 million here, $1 million there adds up to real money. $35,000 is real money.
I agree with you, Supervisor Spencer. And this body in the past has approved, as Supervisor Berlin indicated, many, many, many more dollars than what we are negotiating here to bring something to closure. Okay, I'm sorry.
I'm confused. What's the motion on the floor?
The motion, we've asked the maker of the motion whether he would consider the change in the language, and we have not yet heard.
He doesn't get to choose that. The motion belongs to the floor. If you want to change it, Peter, make a motion.
That's correct, Peter. Yep.
Well, in the past, we have asked the maker of a motion whether he would accept or she would accept different language. I stand corrected. You have a motion, you have an amendment to the motion as Supervisor Kriegel has presented in his language, seconded by Supervisor Von Asten.
And would he please clearly state that motion again? That second? Or how to, that amendment?
Peter, that's...
In his words.
Well, it's Peter's proposed amendment. Now,
Now the chair's making an amendment?
well, we have the original amendment, and then we have
My language isn't.
a motion to amend the amendment. We don't have a second yet. That's correct.
Oh, I asked the maker of the motion if he would be open to changing his language, but I didn't make a motion.
Okay. So,
I'm sorry.
But
We're in a committee of the whole, okay? So let's try to figure out what it is that we want to do.
Supervisor Gibson did raise the point of order on whether or not the amendment belonged to Supervisor Kriegel or not, or that the motion at that point, since it was seconded, belonged to the body. And Supervisor Gibson is correct, that once it was seconded, the motion now belongs to the body, and the individual supervisor cannot agree to any amendment unilaterally. That amendment would have to be agreed to by the body.
So we have a motion and a second, and we are in a period of discussion, is that correct? On Tom Kriegel's amendment, that the board pay $10,000 and the insurance company pay $35,000 to change this wording. That's the amendment. Any discussion on the amendment? I see a lot of lights up. That is what the discussion will be about. Is that correct? Supervisor Dietrich.
Thank you. Let me know if I'm in order or not. $10,000 from the county, period.
Wait, why not from the insurance company?
I said it correct, the insurance company. I misspoke. Okay. Agree to a monetary amount of $10,000 paid by the insurance company, period. No. Not 45,000, 10,000, period. And then if they want to put it behind them, you know, if they want to put this to rest and put it all behind us, then they'll gladly accept it.
I'll second that.
Well, yeah, I don't know if you can do that. The point of order, doesn't that just totally destroy his amendment?
You can modify it.
Yeah. it's an amendment. But you should know, and I think Lori can speak to this, with that amendment, the settlement agreement would, with that amendment, the settlement agreement would be rejected by BNR because we are only agreeing to pay $10,000. And at this point, the specified amount agreed to by
It's just not live streaming tonight.
the other side is 45.
I can speak to that.
Otherwise,
I
we're live
understand
streamed our
the,
whole
I'm not following the motion, the amendment to the amendment. But I'm not following any of that because it's too late for my brain to work. But I can answer Dan's question, which I believe is to the extent there is a an approval to accept the settlement and a payment at $10,000. I can't speak for the BNR. The BNR could accept it if you want my crystal ball prediction. I don't think they will.
But the worst they can do is say no.
The worst they could do is say no. That's true also. But Dan's point is well taken. I mean, if I'm putting my crystal ball on, I don't think they'll pay me. But that doesn't mean that shouldn't be how you vote. That's your decision. And I say that with some background. I mean, as you'll recall in closed session, we did talk about how we got to 45, and that's where the BNR said, you know, that was their number. So I assume that then means that something less than 45 would not be accepted. Yes.
Well, either they want to put it behind them or not. We can throw it out there, and if they don't like it, I'm sure they'll let us know.
So you now have the amendment to the amendment with a motion and discussion on that.
Nobody seconded it.
No, Carl did.
Carl,
We have an amendment to the amendment on the floor to change the wording to $10,000 paid by the insurance company. Is that correct, Supervisor Dietrich? Is there discussion on that amendment? It was seconded by...
But you have to ask him if he wants to speak.
Yeah, what I'm trying to figure out also is the board is lit up, and I don't want to screw up again about who wants to speak in what order. So, although we don't have the technology that I can identify who wants to speak in the second round of the second amended versus the first, I will do my best. Supervisor Dietrich, you have spoken to your amendment, correct?
Actually, I'm just getting started. I don't care what time it is. We're talking about the integrity of the county in addition to money and settlement. So if it takes all day, it takes all day or all night.
But you have specific words.
Yes, I do.
And those are on the floor.
Yes,
And
you know, it's what you said. It's negotiation. It's amendment time. And it's throw it on the wall and see if it sticks. We can use dozens of other superlatives, but I think I sense that we want to get this over with, and BNR's made it clear they want to get this over with. They have attorneys on retainer, for crying out loud. This is a steak dinner for somebody. So $10,000 is more than enough.
Thank you. Supervisor Gruber, do you wish to speak to the motion?
You know, like John said, I mean, this is kind of a compromise for everybody. They get the documents they wanted. You know, we give them a little bit towards their attorney fees. We've had some attorney's fees. It ends it. We don't have to continue through the interlocutory, whatever it was. It brings it to an end. And an insurance company takes care of the other $10,000 on that end of it. They've already said they would. I don't see where there's a loser in that. Everybody wins. That whole discussion we just had for 2.5, almost 3 hours. This sounds, John bringing this up, I think this is a great way of bringing it to an end.
Oh, the only caveat, if I understand correctly, is if the BNR rejects this, it's not brought to an end.
If they reject it, then we come back here and we discuss it next month on what we decide.
No, we haven't agreed to it yet.
Then we come back next month and we just discuss if we'd be willing to go a little bit higher on it. Or maybe the insurance company at that point says, we'll pay the $35,000 just to be done with this. Something that should be asked of the insurance company anyway before this agreement was even brought to us.
Thank you. Supervisor Pepper, do you wish to speak to the motion?
Sure I do. So, if we agree to this, and the insurance company turns it down, or the Baraboo News Republic wouldn't turn it. Oh yeah, they could turn it down. So either one of them turn it down, it's going to come back to the full board. Guaranteed, it's not going to go to E&L or finance. It's coming to the full board next month. Yes or no? Daniel, Peter?
You can make that a condition, yes.
All right. Now, it kind of seems to me like, well, the 45,000 was the neighbor with a great big mean barking dog that had a tendency of eating little kids. He jumped the line fence and he's chewing on your legs, so you don't want to pound on him, but you want to pet him, but then you're afraid you're going to lose your hand. So, now that it's down to 10,000, it's a little ankle biter, little dog, and you just want to help him back over the fence with your other foot. So, I might actually vote for this. Thank you.
Thank you.
Wenzel.
Supervisor Wenzel?
Is there a time limit on this?
It says 30 days.
30 days. Well, it's 30 days from when?
On the day we had signed an agreement. After the execution of the agreement.
I'd like to hear that from an authoritative source.
We're modifying the agreement. We're modifying the agreement, so
Once we execute the modification, then it starts the clock.
I'm not buying that.
What section is? Supervisor Wenzel, I'm sorry. What section are you reading?
I have two people talking around me. I'm sorry.
Which section are you reading?
How long do we have to make
30 days after execution.
to figure this out and make an agreement? What's the interlocutory deadline?
Right now, the interlocutory is on hold, and we can continue to agree as long as the Court of Appeals is willing to agree to continue to move the deadline and maintain it in a holding pattern.
What's that in practical terms? If we look like we're not moving forward, then what?
Well, that's not really something that the Court of Appeals is going to pay attention to. That's really for the BNR and BNR attorneys to assess whether or not they think we're actually serious about resolving this case. And if If they conclude that we're not, then they'll file their answer in response to the interlocutory appeal, and the litigation will move forward at that point.
Okay. All right. The second thing I have to say is, while I did the math, and it's 35,000 out of 91 million is 38 10,000ths of a percent. So that's excuse me, 0.00038. So that is your answer to the math. The other answer, though, is I got three questions. How many play poker? And how many play poker with their hands on the table up? And how many win doing that? That's all I need to know, and it's just a rhetorical question, of course.
Thank you. Supervisor Spencer. Speaking to the amendment of the amendment.
Sort of, yes. In addressing Bill's question, we probably have 30 days before Baraboo News is going to say we're not sincere. Wouldn't you suggest that's the truth?
I can't speak for BNR. I have no idea what their counsel would advise BNR to do.
You were in the negotiation and you know the frame of mind in the room. What I'm suggesting is if we accept John's amendment to the amendment, the signature on the last page here is not relevant because we've changed this as far as they go.
That is correct.
If we accept Tom's original amendment, it really doesn't affect this as far as Baraboo News Republic goes because now we're negotiating with the insurance company.
No, because the original language says the county will pay $45,000. If we modify that to say the county will pay 10 and the insurance company 35, that is a new agreement. And the signature.
We're automatically doing that because we aren't going to pay 45. We're only going to pay
I'm sorry,
30.
I misspoke. You're correct. Right. If this were to be changed to read anything other than the county pays 45, and BNR doesn't care. I mean, that's this agreement between us and BNR. This is not between us, BNR, and the insurance company. We know that there's at least some contribution from the insurance company to pay this amount. So it is, for purposes of this agreement, it is payment by the county. But if we are going to say specifically that it is $10K from the county and $35K from the insurance company or some other third party, this signature in this agreement has not been signed. It's not valid. I mean, it would have to be then agreed to by BNR.
That doesn't make sense because it's the same amount of money.
No, it is the same amount of money, but we're changing the source. And the source of the money would be very important to BNR. Excuse me?
Aren't we already changing the source? Because this says we're going to pay 45.
Well, I think the problem is Pringles wants to amend the document, but Chuck's arguing it from the semantic of within the parameters given to the county board chair. And I think if there were tweaked, that would give you guys the flexibility to not have to redo this document.
Thank you, Supervisor McCumber.
Yes. But if you change the document to specify the source of funds as $10,000 from the county and $35,000 from the insurance company, then
what I'm saying is what Tim said is. Yeah, that's what I'm saying.
But we would have to go back to BNR to get their approval on that modified document because that's not what this document says. That's, that was the question that was
Don't we
raised.
already have to do that or not? Because it doesn't specify in here that 10,000 is coming from the insurance company.
No, it does not. But BNR knew that when they executed this agreement, when Lori presented it to them. And that was the term, they don't care. If we get X number of dollars from a third party, for all intents and purposes, this agreement, we're paying it. Whether we get it from a third party, some of it from a third party or not, for BNR's purposes, we're paying it, and that's what this agreement says, which they've agreed to. But if we change the source, then that changes their interest in the agreement, because they can't necessarily rely on the insurance company paying $35,000. So we would have to get a new, that would be a new agreement.
So we have a motion and a second on an amended wording to simply say that the insurance company will pay $10,000. That is the issue before us. Everybody clear that the amended language to simply say that the insurance company will pay $10,000? Supervisor McCumber.
Oh, I'm sorry.
Thank you. Supervisor Kriegel.
Thank you. Would it have been better to amend what? I guess the blue sheet is not actually the resolution, so would it have been better to have amended the resolution correctly?
The resolution either approves or disapproves of a settlement agreement. The green form is the settlement agreement.
Right, yes.
So
the resolution contains the outlines of essentially your guidance to staff in that constraint, which has already been agreed to by BNR. If you modify the resolution or the agreement, either one, that changes those terms directly or indirectly for the settlement agreement, then there's no signature on it from BNR because we've changed that agreement, and so we would have to go to BNR, get their agreement, and then, of course, we'd also have to get agreement from the insurance company based on your motion.
So I think the answer to your question, Tom, is no. It would not be helpful. Okay, ladies and gentlemen, we have an amended, and if this does not pass, then we go back to the original amended motion.
Mr. Chair, I really wasn't done when I had the floor.
60 seconds. Supervisor Kriegel.
Well, I think Supervisor Dietrich's amendment is about the equivalent of voting no on settling at all, so I would encourage people to defeat that amendment, because it's essentially the same as saying that we're going to carry on with appeal.
Thank you. Supervisor Marty.
Thank you. I can support Supervisor Dietrich's amendment. I believe that this speaks to the amount that our insurance company or our insurance carrier is willing to pay. If the Baraboo News Republic is interested in settling, moving on, getting the records, and moving on down the road, then they hopefully will take this. Otherwise, I believe that it gives also the county time to have any additional conversations with the insurance carrier about increasing their willingness to settle and or preparing to appeal. So I think it takes no money out of the taxpayer, from the taxpayers, and I understand it's insignificant compared to a $91 million budget, but at some point, we need to follow what our insurance carrier is willing to do.
Thank you. Supervisor Von Aston?
Thank you. I'll try to be quick. I oppose the amendment to the amendment. I think it puts the penalty for this mess on the paper, who, in my opinion, is the innocent one in here, is trying to do its due diligence and report the facts to the people. And requested some information we should have gave them in the first place. So, no, I don't support this. I think the insurance company got us into this mess, and they should pay for this. Thank you.
Thank you. Supervisor Dietrich?
Yes, well, that's specifically what my amendment does, is has the insurance company pay for it with what they're willing to pay is $10,000. And it speaks nothing about the sweetness and innocence of the Baraboo News Republic. It doesn't give any question of their character or integrity. It simply says, here's $10,000. You want to negotiate, here's a negotiation. And again, I've been involved with stuff like this before with regard to open meetings law when I was in city council. With Wisconsin Newspapers Association. They have lawyers on retainer. The lawyers are getting paid. Nobody's starving here. It's a principle of this amounts to a speeding ticket, and now we're bargaining on it. So it amounts to principle, and we can argue about whether or not the principal amount is $45,000 or $10,000. But I thought with this whole matter was about the substance, of which we have made no amendments on whatsoever for their open records requests. We're just talking about the money right here at this point, and this is a relevant and legitimate offer.
Thank you. Supervisor McCumber?
Well, and I just wanted to say, I mean, obviously, they inadvertently have a representative here. I think they can understand, and of course it's open record, so they can watch the tape. This doesn't mean that if you vote for it, we've ended all discussion or negotiations with the paper. It's to me seems to be a reasonable way to maybe get this behind it, and I can support that as well.
Does any other supervisor wish to address the amended motion? Seeing no supervisor wishing to address the amended motion, you have a motion and a second to amend the language to the insurance company will pay $10,000 as a change in language. Voting yes approves, voting no disapproves. Please vote now.
Valerie? Okay.
15 yes, 12 no.
Valerie abstained.
4 people.
For the record, I misvoted.
Valerie must have
Abstain.
Valerie abstained.
Yes and yes.
So where are we? 15 no?
15 yes,
15 yes.
and there was 4 non-votes. Not here, excused. Craig took off.
2 excused, 1 abstain, and 1 gone.
3 excused.
27 and 4. 31. So the motion passes. Lady?
Aston, did you guys get Von Aston changed?
No, what was his vote?
Oh.
Scott, what was your vote?
I'm sorry.
You said you changed your vote?
I'm not changing my vote. I misvoted, as we all know. I just want to say for the record that people acknowledge that I meant to vote no. Doesn't change the outcome of the vote, so it's fine.
I'll
Although
make
may
it say
change-
no.
It may change Valerie's position.
He said you don't have to change it.
Don't change it.
Yes.
Change it.
I would like it changed, yes. But we shouldn't argue about it because it doesn't change the outcome.
So is that then 14 to 13?
13 to 15.
14
It would be
to
13,
13.
14.
Oh, yeah, because the abstain is.
Right, right.
So what is,
It still avails, but then Valerie,
it's 14 yes, 13 no, 1 abstention, and 2
but does that change Valerie? It
So it's
can't
15,
change
14.
Valerie's vote. Right.
Passes.
Yeah, then what
Is the abstain counting as a no?
No.
No, the abstain does not
15,
count as a
13.
no.
14, 13.
14, 13. Okay, ladies and gentlemen, the amended motion carries 14 in favor, 13 against, 2 supervisors absent and excused, 1 supervisor abstaining, and 1 supervisor gone. So the settlement agreement will be amended to include that language. And now we need to come back to approving the modified resolution.
Don't we have to vote on the other amendment first?
No, that,
No, the amended motion carried, so that changes the
yes.
amendment.
Yes.
So you usually vote on an amendment to amendment and then vote on the amended amendment.
Vote no, you'd have to come back to the.
Correct. And, right.
Your amendment doesn't exist anymore, Tom, because John's over all on board.
Right.
Okay, we're almost done, folks. We're almost done. You have done yeoman service. We have had 2 very substantial issues before us that have taken up the immense amount of time of the board and of our invited guests and of our citizens. So let's bring this to conclusion. My understanding is that we now have a amended settlement agreement with the language that you just voted to place into it. And now we are going to approve the do we have to do that first?
Right. Yep, it's back to the general discussion.
We don't have to do that yet. Okay, Supervisor Dietrich, thank you. Keep me.
There's a number of requests in here that I don't agree with, but this is all about negotiation, as you said, Mr. Chair. But I do have one in particular that just glares out at me, and it is one that was brought up by the administrative coordinator. And maybe if we pursued with the attorneys from the insurance company, we would prevail. But, just for argument's sake and for the sake of getting this, getting past all this, moving forward, as both the BNR says it wants to do, and we definitely want to do, I move to amend the last sentence in request number 3, that the document that will be generated by the county shall contain the exact language used in the exit interviews be deleted entirely.
Where you at? What page?
The last page 2, request number 3, the last sentence be deleted. That we will not provide exit interview information.
It's just the language in the interviews, not the interviews.
Point of order, is the intent with that to just not give any information from the exit interviews?
Correct.
Then I think that what you need to do, if that is your will, is to remove subsection 2 altogether, not just that sentence.
Subsection 2.
So it would be B2.
Got it. Thank you.
So not just the last sentence.
Okay,
the
yep.
entirety.
Right. Okay,
Yes.
Okay,
That's the intent.
thank you very much. That is my intent, and I thank you, and forgive me, Corporation Counsel. I move for B2, request number 3 to be stricken.
John, is it
On
on page 2?
page 2, yes.
Are you seconding that?
We have an amendment by Supervisor Dietrich, seconded by Supervisor Wetzel. Would you repeat it, John? Thank you.
To remove on page 2, B2, request number 3.
In its entirety.
Correct.
Supervisor Wetzel, would you like to speak to the motion?
Yes. I believe that if you're going to get quality exit interview information from employees who are leaving employment with your organization, and you want good, honest, accurate information, you can't give that up. Otherwise, you're going to either have people that refuse, as I have in some of the organizations that I've been responsible for. You're going to have people refuse to fill them out, or you're going to have people that are going to refuse to be honest and open about the information that you're trying to seek. Thank you.
Thank you. Supervisor Wenzel?
I'd like to request an answer from council back there. Why is the 2B different than the proceeding in request number 3? My understanding is that we're only talking about 2 exit interviews. Is that correct?
That is correct. The request was broader than that, but the reality is there were only 2 exit interviews that were within the gambit of what was requested.
Okay.
Now, I'm sure there are more exit interviews that exist. I can only tell you that of what was requested, there were 2 responsive documents.
And that's what's in here.
Correct.
Okay. So, and both of those are fine with having your exit interviews made public?
So I will defer that question back up there because I did not personally speak with those people, but it is my understanding they were fine with portions. Aileen, do you want to speak to that? I feel like I'm relaying third-hand what I was told. Was somebody up there?
Yeah, I mean, I only spoke to one of the people involved, and they were fine with that.
So both parties are fine with that. So why are only one?
Well, Daniel spoke to the other party.
Right.
Yeah, speak up louder, please.
Yes. I mean, so we have agreement from the parties, essentially.
From both parties?
Yes.
There are exit interviews in its.
I've got the
No.
floor, please.
No.
I've got the floor.
Yeah, Chuck.
1 or 2?
Both, but we are not releasing exit interviews. This only is releasing the
2.
contain exact language in the interviews, as well as summary of, because it provides for the creation of a document containing content from the interviews. So as this agreement currently reads, we are not releasing the exit interviews that were prepared by the 2 former employees. We are only we're taking some of the content and creating a separate document.
It's a little rough to differentiate since we don't have that information in front of us. I think you'll have to agree.
I'm sorry.
We don't have that information in front of us to know exactly what's in them. Can you help me out there?
We shouldn't be talking about that.
Right.
Can you do an hypothetical?
No.
I mean, all I can tell you is that we are not giving the exit interview. We are not releasing, under this agreement, we are not releasing the exit interviews.
Okay. So, it is an appropriate thing then to differentiate between the first paragraph and then the second paragraph. They're different in meaning.
You're looking at B2.
Yeah. Request number 3, I believe.
Right, I only see one paragraph. I mean, there's indentations for sub 1 and sub 2. Are you looking at the last sentence? The
Yeah.
document that will be generated?
Yes,
Okay.
I assume that's what we're talking about. The paragraph preceding that, it says the 2 exit interviews that were withheld.
Correct.
So what's the difference between that and the document that would be generated? Are they only excerpts of those exit interviews?
Correct.
Okay,
Without identification of the individuals from which they came.
okay. So,
And the exit interviews do contain, I mean, they provide, they have standardized questions for responses. And that was something that we can release because obviously there's nothing that ties that standardized language to any particular employee.
that does not tie it to any,
Specific employee.
okay, that's what I thought you said. So, if we kept that sentence, the document that would be generated, it wouldn't be tied to a specific employee. Is that correct?
That's correct.
So whose butt are we covering here by taking the sentence out? Why are we considering taking that out? That's what-
You would have to ask Supervisor Dietrich that question.
I'd like to
That
ask
is
that.
his motion.
Yeah, I'd like to ask that.
If I can.
Supervisor Dietrich.
Okay. As Supervisor Witzel had stated earlier, if we want honest and open exit interview processes, these must be privileged, this must be privileged confidential information at every level and its entire content. Otherwise, we will not get honest, frank interviews from anyone. We might not get interviews from anyone. And how do you improve your organization? I object to potentially leaving any type of precedent with regard to employee exit interviews open for to be viewed by the public, and as this could potentially damage the career and reputation of the employee, let alone the county. This is in the best interest of every employee in Sauk County that we delete this. This is not a small thing.
It doesn't say that. It says 2 exit interviews that were withheld, and one person, as I understand it, is
No, but it sets
okay
the
with it.
precedent, and I really
The
don't
precedent,
care.
we're deciding a precedent right here. There's no
Exactly.
precedent
To direct
because
Bill
these
to
are
direct his
individually
questions and
talked about
communication
like
to
we're
you
doing
as
right
chair.
now. So I don't think this sets a precedent at all.
Thank you, Bill. Thank you, Supervisor Dietrich. So you have Supervisor Witzel.
I do believe that it's inappropriate for us to not name the employee or former employee that left the employment of the county. While there may be derogatory things contained in some of the comments that were on that exit interview about employees who are still with the county. I believe that I'm not an attorney, but I believe that there's a great deal of litigation, maybe some both ways, but I think the supporting litigation indicates that exit interviews do not have to be released. And I also wonder about who's going to make the decision about what gets included and what doesn't.
We already have, and none of it is derogatory towards anybody,
Okay.
as far as I remember.
Right. I think we need to clarify. Right. We need to clarify that as a part of the discussion, the request, although it was material that was in exit interviews, the interest was in the material, not the exit interview as a whole. And in discussion, please correct me if I'm wrong, in discussion, we identified the general language within the interviews without indicating the individual that created that exit interview, but just picked a very specific language that the BNR was interested in and created a new document that listed just the words that they were interested in. So we're not releasing exit interviews. We're releasing a specific request of information regarding a personality that was attached in exit interviews.
But no names either of current or former employees are going to be released?
That is correct.
And the comments that are going to be released, or the statements that are going to be released, will not be such that they will easily identify the people who are referenced? You follow what I'm saying?
Yeah.
So if somebody is working in the school district of Wisconsin Dells and they hate the superintendent, they say they hate that guy on the top of the heap, well, they all know it's the superintendent. You follow what I'm saying?
Yes.
Okay.
Yes.
Yes. You have two exit interviews. So unless one of them speaks and says, that was not me, then, or that one was me, then you're not going to be able to identify.
That's the former employee, right?
Well, that's all that we're talking about. This only deals
What
with
he's
the
saying
two.
is, could it
I'm talking
identify?
about the people who are still here, who may have been referenced in those exit interviews.
They were not.
Okay.
Supervisor Von Asten.
Thank you. This is my first time speaking. So I think Chuck got to go twice.
We're in a committee of the whole. I apologize. No, we're not.
Yeah, let's go in order. Anyway, I would like to say that one, I don't believe this sets a precedent, but if it in fact does set a precedent, because Lord knows, but if it does, what's the precedent? The precedent is that we will allow for the paper to be able to request a summary of an exit interview that the people that are involved personally in the exit interview agree to. If we're setting a precedent, that's what it is. But, it wasn't a few minutes ago that we said, let's change this to $10,000. Let's offer the paper $10,000 because we're giving them all the information they asked for. And then 5 minutes later, we start trying to take away the information. Come on. We just passed the amendment because that was part of the deal that amendment was sold on. And now we're backing off it. We're changing that. So which part of it was true a minute ago? Thank you.
Thank you.
I think this could be construed as that.
Marty?
Well, I guess I think we've already settled that these two exit interviews were negotiated. The content, correct, Mr. Corporation Counsel?
Excuse me.
The content of those two specific exit interviews was negotiated and approved by the employees?
The content was negotiated?
Well, I mean, what the snippets or whatever partial pieces of those exit interviews it's been reviewed by the...
Right, they were informed of what the content was.
And do you believe that the news... Now, it's hard for me to believe that the newspaper will be interested in something that, as Chuck is concerned about, that is not derogatory or cannot identify a former employee or something, but let's go with that. Do you believe that leaving this in there for these two specific exit interviews presents a opportunity or opening for the newspaper in future to request exit interviews?
The exit we are not.
Because I think that's Chuck's worry is that.
Mm-hmm. I do not, because we are not releasing the exit interviews. We are releasing a summary of some of the content based upon what the newspaper was particularly interested in, and we identified some content that was related to that interest. And they were satisfied with that.
See, and if that's the case, if it doesn't set a precedent, I can't believe I'm saying this. I agree with the guy sitting in back of me.
Oh, my God.
No, I mean, we had, somehow we reached a compromise to change the dollar amount, and all of a sudden, now we're also pulling back other things. I would have, in the interest of getting this done, if those two interviews had been, you were totally involved in them, and if it's not the entire interview, if it is specific sections that are agreeable to the county and the employee to release, I would have gone with that, as long as it doesn't open us up to future exit interviews being open, to revelation.
No, the request in this particular case was very specific and related to a particular office, as you can see from
I know who you're talking about.
From the language in the agreement. Can I say that there might not be similar public circumstances that might be generated in some other department that would lead the newspaper to make a similar request? Yes. Would we release the exit interviews based upon what we're doing here? No, because we are agreeing not to release the exit interviews at all, just some of the content.
Thank you for that answer.
Yeah.
But I do want to clarify that. I do actually think some of it could be somewhat derogatory. It's not like anything, like I hate this person or anything like that. But it's, yeah.
Okay, we have a motion and a second on the floor. We're having a discussion regarding the issue of removing in its totality B2 request number 3. Supervisor Pepper, please speak to that issue.
Yes, I am. Thank you, Mr. Chairman. Thanks, Marty, for acknowledging I'm on behind you. This.
Not very often I agree with you, Brian.
Yeah, I know it. If we take that out, and we pass this resolution like that, what stops them 3 months down the road from requesting it again?
And if they do, we don't have to.
It's not, it doesn't say that they can't re-request it.
They can call them and get it, because they will talk.
You have a question or an answer, Dan?
Can we? Well, let me answer it this way. Can we draft a document that would prevent the newspaper from asking questions about exit interviews in perpetuity? No, we cannot. This document won't do that. No document will do that, because they have the right to ask under the statute. And then we have an obligation under the statute to respond to their request based upon whatever that request is. Yeah.
Isn't there a county board policy that prevents us from giving that information, or internal? There's certain shit that just shouldn't be out in public, you know?
Yes, there is in your ethics code, there is a provision that relates to confidential information and prohibits disclosure of that confidential information in an inappropriate manner. I don't have the exact language in front of me, but there is an ethics code provision that basically says you don't get to go share confidential information.
Eventually, if they keep shooting at this bulletproof glass, it's going to crack. And then they're going to get a hole in it. And then next thing you know, you have a broken system again.
Thank you, Supervisor Pepper. Thank you. Supervisor Spencer?
If we leave this in and we give them the information that you have redacted or not pulled out from the original? How do we know they're going to be satisfied with it?
They've already told us.
Well, that's my problem with this whole negotiation. You already must have given them the information they wanted.
No, we have not given them anything, but we have at least described the information that is available in the exit
So
interviews. And
They've agreed in principle, but
if they execute
might not be satisfied.
and if they execute this document and we fulfill it within the terms of the document, that ends the request.
Supervisor Miller.
Thank you, Chair. I urge people to vote against this amendment. It seems to me that we're confusing things here, that we're talking about a specific incident, a specific agreement that has been already run by the two people that are concerned with it, that they have given their approval. And what we're doing, in effect, is saying, well, let's expand this to something else. Let's make it cover all exit interviews when it doesn't. When the specific language in request number 3 is only talking about one particular isolated incident that has been agreed to by all parties. So I think that in all due respect to Supervisor Dietrich, I think that we should stay with this request number 3 here. Thank you.
Thank you. Supervisor Gibson.
Thank you, Mr. Chair. I have to agree with Supervisor Miller and Supervisor Van Osten is that the caveat of agreeing to the previous one was the stipulation that the Baraboo News Republic was getting everything that they were requesting. The other thing that I'd like to mention is before we get too far in the weeds with this is we're negotiating against ourselves because everything we discuss here, however it turns out, Baraboo News Republic gets to look at this video and is privy to every move we're going to make. So if we're going to decide on something to vote for, let's decide on something minimal. And then if it's going to go back and forth, I'd much rather we went back and forth in private than in public. And that's what we're doing with the tapes running now. So.
Thank you. Supervisor Dietrich.
Thank you. I mean, it sounds really sweet and innocent when you read, the county will create and provide a document containing certain content from the 2 exit interviews that were withheld. And then that very last sentence, the document that will be generated by the county shall contain the exact language used in the exit interviews. That is not a summary. That is not a generalization. Which one are we talking about?
Whose language was that at the table?
I mean, Corporation Counsel was saying that it was going to be a summary content that would be given to the Baraboo News Republic. And then the very last sentence says the document that will be generated by the county shall contain the exact language used in the exit interviews.
But John, the document that is being referred to is the document that takes the language that has been agreed upon and put into something separate. That document is referring to the specific words that were coming out of the interview, exit interviews that were agreed to. So I'm just concerned that maybe you're seeing the word document and you're thinking that that means the whole ball of wax when it simply means that's the second piece of paper, or rather the third piece of paper that contains words from exit 1 and exit 2. That is the document that's being referred to that we're giving them. It's the words that they've already agreed to accept.
Forgive me, but the interpretation that could be done here looks like it could be something very, very terrible at best.
Thank you, sir. Supervisor Witzel.
Just one last thing. I believe that the county is creating a document, and under the open records law, a municipality cannot be required to create a document that does not already exist. I realize that this may satisfy the Baraboo News Republic in in their effort to get information. I just want to remind everybody that a municipality is not required to produce a document that does not already exist. Thank you.
He's already spoken a dozen times. Supervisor Spencer, did you wish to speak again? Please do.
I'd be a lot more comfortable if I knew what was in that document, your creation of that document. I'd be a lot more comfortable if I knew what was said about the court counsel and the management of the court counsel.
Well, we'd have to go back into closed session.
Pardon?
We'd have to go into closed session to do it.
Yeah, I don't mean now. I mean,
We don't have to.
In closed session, I would have been more comfortable.
Yeah.
Thank you. You have before you a motion and a second to amend the language of B2, request number 3, to remove it entirely. There's no more discussion on that amendment. Let us prepare to vote. Please vote. I'm sorry. If you vote yes, you are approving the amendment to remove that language entirely. If you vote nay, you are voting to leave that untouched. Please vote now. Four yes, 23 no, one supervisor gone, and two supervisors excused and absent. Donna's absent. Two supervisors absent. Supervisor Brunschweigen. Yeah, he was ill and went home. Anyway, the amendment fails. We'll get her vote. It won't change the outcome.
We're good. Move on.
The amendment fails.
Yes.
Correct.
Okay. Back to the original. Is that it?
Yep.
Do we have to now vote
Vote on the resolution
on the resolution as
amended.
As amended.
Ladies and gentlemen, we are at the final gate before we move into the next day. It would be very nice for us to retire before hitting the next day. You have before you Resolution 12-2019 and a motion and a second to accept the resolution as modified for the litigation settlement.
We already have a motion.
I said we have a motion
Yeah,
and
no,
a second.
yeah.
Right. We have a motion and a second before us to approve the resolution as amended. Please prepare to vote. Please vote now. The amendment passes 23 yes, 5 no, 2 supervisors excused and absent, and 1 supervisor gone. Supervisor Von Asten. Motion to adjourn, seconded by Spencer. All in favor, please say aye. Aye. Opposed? We are adjourned.
I would think it would be. I don't know.
It's public.